I've been a great admirer of Noorani Sahab, and in my formative years as a lawyer, reading his articles in either Frontline or EPW was such a joy, just for the thoroughness of his research. And as Iqbal Sahab mentioned, and Dr. Shamama also mentioned, brutal honesty, never afraid to speak, and will always cross-reference everything that he states. It's usually heavily footnoted, cross-referenced, and so any researcher in this room will find it a delight to read Noorani Sahib, the thoroughness with which he presented facts, and completely fearless. So he's been always an inspiration, and I'm doubly honored to be called upon to deliver a memorial lecture in his name. I'm going to be conscious of the time, so I've had to restructure my lecture. No, because I know there will be a lot of reaction to the lecture, and I'm anticipating that. We want that. That's the whole purpose of this lecture. So I'll try and finish it in about 40 minutes, and then I'll prepare to take questions. India's population is diverse as well as devout. Not only do most of the world's Hindus, Jains, and Sikhs live in India, but it is also home to one of the largest Muslim populations and to millions of Christians and Buddhists. We never were and cannot conceivably be a nation of one culture, one language, one religion. What makes us proudly Indian is diversity and plurality. In a 2023 book titled Indians, Histories of a Civilization, edited by the renowned linguist Dr. G.N. Devi, he speaks of colonial writings on history which tended to essentialize India as a land of the Hindus, while Muslims were projected as invaders. The Vedic culture, Brahmanism, and Sanskrit were associated with India, while Muslims, Arabic, and Persians were deemed to be foreign. It was a colonial master's vision, and their writing of India's history led to these dichotomies. That book is a collection of essays which point out that history writing privileged religious conflicts and the role of dynastic rulers and kings. Non-Brahminical traditions such as Jainism, Buddhism, Dravidian culture, and Adivasi history were ignored. Class conflicts and the caste question, gender inequalities were largely not touched upon. As late as the early decades of the 20th century, the narration was limited to the Hindu-Muslim binary and the glorification of the past. Unfortunately, we find prominent sections of the electronic media in the country feeding on TRPs, also harp on the Hindu-Muslim question and fail to recognize the composite nature of Indian culture, the plurality of its societies, and the diversity of its practices. The Indian version of secularism, which the Supreme Court of India declared in 1973 to be a basic feature of the Constitution, is different from the kind of secularism known to the Western world, which speaks of a strict separation between the church and the state, or the French version that says that a state can interfere in religious affairs, but religion cannot interfere in state affairs. We do not subscribe to either of these versions of secularism. Scholars have variously termed it as live and let live, tolerance to all religions, sarva dharma sambhavana, and principled distance between religions. In the Constituent Assembly, attempts at introducing the words secular, socialist, and federal in Article 1 of the Constitution failed. M.V. Kamath wanted to table an amendment whereby the Constitution would begin with the words, in the name of God, we the people. He faced immense resistance from the members of the Constituent Assembly, signaling their intent to preserve secularism as a constitutional value. Purnima Banerjee said, and I quote, "Mr. President, the name of God is invoked by every nation upon earth, and God is an impartial entity, and he should be allowed to remain so. With these words, I appeal to Mr. Kamath not to put us into any embarrassment of voting upon God." The word secular stood inserted along with the word socialist in 1976 through the 42nd Amendment. There is one other reference in the Constitution to the word secular, and that is Article 25, Subarticle 2, Clause A, which talks of freedom of conscience and the free profession, practice, and propagation of religion, and says nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. The word secularism otherwise permeates the whole of Part 3 of the Constitution when we read Articles 14, 15, and of course Articles 25 to 30 as one scheme. The recognition is not just of religious and linguistic minorities, but even those with a distinct culture. Article 51, capital A, clause E, states that it shall be the duty of every Indian citizen to promote harmony and the spirit of common brotherhood, transcending religious, linguistic, regional, or sexual diversities. Clause F enjoins them to value and preserve the rich heritage of our composite culture. And the word composite is very interesting because there are so many of us who in our growing years were aware of this composite culture. I come from Tamil Nadu, and as a child, I've been taken by my parents on a pilgrimage to this city called Nagapattinam, which is a coastal town in Tamil Nadu. Nagapattinam is so unique that it has a church which goes by the Velankani church. It's on the coast. It has a dargah called the Nagur Dargah, and it has a temple dedicated to Lord Kartikeya. So it's very common even today for devotees to do a pilgrimage of all three shrines. They're all within a triangular radius of 5 to 10 kilometers. And as a child, I've been taken to all three places. And that is really what we call the composite culture, that we don't differentiate. We throw open our places of worship and we make it something common that all of us will cherish and grow up with. And it nurtures that spirit, that fraternity that the Constitution talks of. We seem to forget this every now and then, and it's important to remind ourselves that our culture is a composite culture, which is what the Constitution talks about. The Indian notion of secularism, as understood by the judgments of the Supreme Court, is one of tolerance of all religions. I'll just not spend too much time on these quotations. I'll just cite a few of them, which is in the famous case of S.R. Bommai versus Union of India. And the majority was comprising of at least 5 judges. It's one of those judgments where scholars are still trying to find what the ratio of the case is. But one thing on which all the judges were agreed upon is that secularism is part of the basic structure of the Constitution. This is Justice Sawant, who forms part of the majority. Religious tolerance and equal treatment of all religious groups and protection of their life and property and of their places of worship are an essential part of secularism enshrined in our Constitution. We have accepted the said goal not only because it is our historical legacy and a need of our national unity and integrity, but also a creed of universal brotherhood and humanism. It is our cardinal faith. Any profession and action which go counter to the aforesaid creed are a prima facie proof of the conduct in defiance of the provisions of our Constitution. Then we have Justice K. Ramaswamy, who states very pointedly, the state does not extend patronage to any particular religion. State is neither pro-particular religion nor anti-particular religion. It stands aloof. In other words, maintains neutrality in matters of religion and provides equal protection to all religions subject to regulation and active acts on secular part. Now we have Justice Jeevan Reddy, who builds on this and says, secularism is thus more than a passive attitude of religious tolerance. It is a positive concept of equal treatment of all religions. This attitude is described by some as one of neutrality towards religion or as one of benevolent neutrality. This may be a concept evolved by the Western liberal thought, or it may be, as some say, an abiding faith with the Indian people at all points of time. That is not material. What is material is that it is a constitutional goal and a basic feature of the Constitution as affirmed in Keshav Nanda Bharati and the Indira Gandhi versus Rajnarayan cases. Any step inconsistent with this constitutional policy is, in plain words, unconstitutional. All these observations were made in the context of the aftermath of the demolition of the Babri Masjid. Just to go back in history, it's not too far back in history, we're talking of 33 years. The state governments of Uttar Pradesh, Rajasthan, Madhya Pradesh, Himachal Pradesh were dismissed, and President's rule was imposed under Article 356 of the Constitution. And that was challenged. In Madhya Pradesh, it was struck down as unconstitutional, the act of imposition of President's rule. So there was an appeal by the Union of India to the Supreme Court. The Supreme Court also withdrew to itself the other challenges. And this was a judgment delivered sometime in April of 1994. The backdrop was certainly the destruction of the Babri Masjid. And that one event actually changed the course of our political and constitutional history. And therefore, it's a very, it's what I must say is the turning point. I would definitely call it a turning point in how we, as a judiciary, responded to all these situations where we were called upon to test this constitutional value of secularism. Do we really abide by it? Are we serious about it? Or are we being pragmatic about it? Are we ready to compromise over it? So these questions emerge from this one incident and therefore the litigation that is associated with this one incident. So I must foreground the lecture with some discussion of the Babri Masjid case itself. On 24th December 1885, and this is where litigation around the Babri Masjid starts. On 24th December 1885, the civil judge, Faizabad, observed while dismissing a suit by the Mahant of that time, who wanted to build a temple on the Chabutra, not in the main area where the mosque stood, but in the Chabutra, which is on the outer courtyard. That suit was dismissed, saying, and I quote, and this is 1885, if a temple is constructed on the Chabutra at such a place, then there will be sound of the shank and of bells of the temple when both Hindus and Muslims will have to pass from the same way. And if permission is given to the Hindus for constructing a temple, then one day or other, a criminal case will be started and thousands of people will be killed. This is a civil judge in Faizabad speaking in 1885. His judgment was appealed against. The judge went before a Britisher, Colonel Chamier. He dismissed the appeal on 18th March 1886. And I quote what he's saying: "It is most unfortunate that a masjid should have been built on land specially held sacred by the Hindus. But as that event occurred 356 years ago, it is too late now to remedy the grievance. All that can be done is to maintain the parties in status quo. In such a case as the present one, any innovation could cause more harm and derangement of order than benefit." The further appeal was dismissed on 1st November 1886 by the then Judicial Commissioner. It appears that the Babri Masjid was itself declared a Waqf property under the UP Muslim Waqf Act of 1936. A litigation then ensued between the Shia Muslims and the Sunni Muslims on the right to worship at the mosque. And this ended in a judgment dated 23rd March 1946, with the civil judge in Faizabad holding that the mosque had been used both by the Shias and the Sunnis. For those who may be interested in some trivia, this judgment of 23rd March 1946 was challenged in the Supreme Court by way of a special petition, which came to be dismissed for delay of 23,000 days on 9th November 2019, when they disposed of the appeals arising from the judgment of the Allahabad High Court. The next important date, we are in 1946, the next important date was the intervening night of 22nd and 23rd December 1949. I'm referring to these things because you will see the involvement of the judiciary at every point in time and how that completely changes the trajectory. In the intervening night of 22nd and 23rd December 1949, one Abhiram Das and his brothers climbed over the wall and broke the locks, placed certain idols of Ramlalla under the central dome of the Babri Masjid. Two first information reports were lodged, FIRs were lodged on the very next day with the police station at Ayodhya. And one of them reads, according to the oral information given by Constable Mata Prasad when he reached the Janmabhoomi at about 7 a.m. that day, he came to know that a crowd of about 50-60 men had, by breaking open the locks which existed in the compound of the Babri Masjid, and also by jumping over the wall with the staircase, entered inside the mosque and installed an idol of Sri Bhagwan therein, with the writing Sita Ramji, etc., with red ochre and yellow paint. There's another version, of course, which insists that the idols had appeared miraculously in the mosque. The word went around, Ramji Prakat Hue. So proceedings were initiated by the executive magistrate for breach of peace under the same section 145 CRPC, which was also the same number in the 1898 version. On 29th December 1949, the magistrate ordered the attachment of the structure and appointed the chairman, Municipal Council Faizabad, as a receiver to take charge of the structure. So this judicial intervention actually changed the course, because this order appointing a receiver, giving him possession of the structure, was approved by the High Court of Allahabad. And 30 years later, when that receiver died, the High Court, by an order dated 20 July 1987, simply appointed a substitute. But what is significant are the civil proceedings that started very soon after. So on 16th January 1950, one Gopal Singh Visharad, who was a devotee, filed a suit for injunction, and he asked for restraint on removal of the idols. This was promptly granted 3 days later in January 1950, and it was challenged before the Allahabad High Court, which affirmed it on 26th April 1955. So this was the beginning where the status quo with the idols under the central dome continued because of judicial orders. So the last date which is recorded in the judgments of Muslims worshipping in the mosque was 16th December 1949. But what it also meant was this, that there was a constant attempt at changing the status quo. Although a wall was built between the area where the mosque stood and the outer corridor, there were constant attempts to see whether we can breach that status quo. There were riots in 1934 during the British times, and the domes had to be repaired. But after independence, with this 1949 event of intervening night of 22nd, 23rd December, it already somewhere altered the status quo, and every now and then some attempt would be made to challenge it. Things remained rather quiet on the political front as far as this issue is concerned, but there were stirrings. There were stirrings every now and then. There would be resolutions passed by the right-wing groups, the Janasangh, and later the Bharatiya Janata Party, the VHP, saying that we must have a movement which establishes the temple of Ram at where the Babri Masjid stands. This is the view of some of the scholars, and Salman Saab is here, that the Shah Banu judgment, with which I think he was very closely associated in many capacities, the Shah Banu judgment provided an excuse to rake up the whole issue. As many of you would realize, that she was a Muslim woman in Indore in Madhya Pradesh who had gone to the court seeking maintenance. And she was given a maintenance, would you believe it, of 25 rupees a month. That was challenged by her husband. The High Court then increased that maintenance by another 150 rupees or something more. She ended up, she would have got some 179.20 paise. That was challenged by her husband in the Supreme Court. So the Madhya Pradesh High Court, of course, turned down his challenge, saw section 125 CRPC as a secular provision, and said the Sharia law does not prevent a Muslim woman from seeking maintenance. Matter should have ended there, of course, but he took it to the Supreme Court, and the Shah Banu judgment was delivered on 23rd April 1985, where we know now that the court upheld the Madhya Pradesh High Court judgment and said the Muslim woman's right to maintenance under the CRPC provisions is not taken away because of the provisions of the Sharia law. There was a huge outcry in the country. Muslims saw it as an invasion of their personal laws, and There were protests. There was a polarization even within the Muslim community. And of course, this incited those asking for, stopping of the appeasement of minorities to ramp up this demand for the building of a temple for Lord Ram on the site of the Babri Masjid at Ayodhya. And it was the Rajiv Gandhi government. It had come with a thumping majority in 1984. And within a year, things were unraveling. There was a by-election held, I think somewhere in 1985, where the Congress did very badly across the country. And so the then Prime Minister's advisors probably said that he should now start doing a middle path and start appeasing both sides. So it's commonly believed that the tacit approval of the breaking open of the locks of that separation of the wall was because the government saw Rajiv Gandhi as having appeased the Muslims by getting the parliament to pass a law to overcome the Shah Banu judgment. So what was that law? That law simply said this, that the Muslim woman would be entitled to some compensation during the iddat period of 90 days and not thereafter. And she need not necessarily get it only from the husband. This, of course, didn't satisfy people because they saw this as an unnecessary interference with the judgment, which was seen then as progressive. But it also got triggered with the fact that Shah Banu herself publicly said that I do not want this maintenance. I do not approve of the judgment of the Supreme Court. She was under tremendous pressure by her own community to do this. So on the one hand, Rajiv Gandhi's government was seen as being weak in not trying to enforce a judgment of the Supreme Court. And somewhere to compensate for that, the locks of the outer corridor were opened to give free access to public. But Nilanjan Mukhopadhyay, who's written a wonderful book, which I came across while preparing for this, says that it didn't quite work like that. Somewhere sensing this change of mood, one Umesh Chandra, who had nothing to do with the suits, by this time in 1986, there were already 4 suits. There were 3 suits by the Hindus, 1 suit by the UP Central Sunni Waqf Board. And that was also seeking a declaratory relief of possession and title. This Umesh Chandra suddenly springs up, goes before the district court, goes first before the civil court, and says, break open the locks. I have a right to worship. The public should have a right to worship. The Hindu devotee should have a right to worship. It's thrown out, but he goes on appeal. In the appellate court, within 3 days, an order is given for breaking open the locks. And so this was another act by the judiciary, by the district judiciary, which completely altered the status quo. The locks were opened. And this again was not interfered with, except by saying, the High Court saying, don't change the nature of the property. So what it meant was, from this point onwards, people entering for, praying at that site where the idols were installed began. And so this is the point, even in the later judgment we see in November 9, 2019, whether there was a right to worship being recognized and whether it was actually exercised by the Hindus in Ayodhya. That was a question that was posed by some of the judges. Now we need to travel a bit around this issue. Since this was a boiling issue, the UP government decided to step in, invoke the Land Acquisition Act, and in 1991 passed notification saying that we are acquiring this land in and around the mosque. That was challenged. The challenge was pending in the High Court in Allahabad. Mohammad Aslam Bhuri filed some PILs where he said, listen, every day there's a lot of tension. There's a threat to law and order. The Hindus are congregating in large numbers. The Muslims are unable to access the place. So you must pass orders protecting the place, preserving the status quo, because that is the tacit understanding of all these orders. So when the bench of Justice Venkatachalya was hearing these matters, constant assurances were given to the bench. And by then I was a lawyer in the Supreme Court, and I'm sure Indra will also recall these days. The courtroom would always be packed, and we would have Mr. K.K. Venugopal appearing for the UP government, giving solemn assurances, and his advocate on record, I think, was Adarsh Goel. So they would give solemn assurances saying, no, nothing will happen. We have reports, we have these messages. So every hearing, there would be an assurance given to the Supreme Court that the status quo would not be altered. But the tipping point happened like this, that on 28th November, a longish order was passed by the Supreme Court permitting what the, the groups called, the Hindu groups called as a symbolic kar seva. So it was supposed to be symbolic. It was supposed to happen in the outer corridor, the Chabutra area. And assurances were again given, which was recorded in the order of the Supreme Court, that the structure will not be touched and it will be protected. But what happened after that is now what we call history. So on the morning of 6th December 1992, the demolition started, and it was all over, if I understand right, by 3 o'clock or 3:30 in the afternoon. Rakesh Bhatnagar writes about it, and it's all there on the net for anyone who wants to go and see it. He's a journalist with the Times of India at that time. He says how our standard public media at that time, AIR and Doordarshan, was not carrying any news yet. It was only the BBC that was broadcasting this news.
I did that.
Very well.
I was there. I was with them.
So when he saw this on the BBC, he says how some of them had satellite dishes and they could get the BBC channel. He immediately called up the residence of Justice Venkatachalya. Of course, the private secretary said, no, Saab is busy, or Saab is not available. But he could hear Justice Venkatachalya's voice, and the next thing he knew, Justice Venkatachalya has taken the phone from his secretary. And he asks, who's this? And Rakesh introduces himself and says, Saab, this is happening. He says, no, it can't be. Where did you see it? He says, on the BBC. He says, how can you see BBC? We are not able to see. So the thing is, the Supreme Court judges only had the regular channels of AIR and Doordarshan. Then Rakesh had to take the phone and place it near the television set where it was all being announced. And it's then that Venkatachalya realized that what he was saying was true. So there was a hearing in the residence of Justice Venkatachalya at 5 p.m. on 6th December, where he's supposed to have given Mr. Venugopal a dressing down. And Mr. Venugopal told the court, my head hangs in shame. And from that point, Mr. Venugopal withdrew from the case. But the point was that at 5 p.m. when the hearing happened, Mr. Milan Banerjee, the Attorney General, informed the court that President's rule had been ordered in UP. And with that, Justice Venkatachalya is supposed to have said, then we won't pass any further orders. So that was the point which led to the Bommai judgment, where secularism was reaffirmed as a basic feature of our constitution. Things didn't get resolved easily because there was one important factor which I should mention, which happened before all this happened, which is the passage of the Places of Worship Act in 1991. The parliament of that time and the government of that time, of course, anticipated that this will be a festering issue which will not be possible of easy resolution. And if we allow this one issue to spring up, there are several other issues waiting to spring up. And so they passed that law, and I'll refer to it in a while, knowing fully well that there is going to be a problem at hand if we don't stop it right now. So even while the Place of Worship Act was there, the 1991 Act was there, which froze the status quo as to places of worship as on 15th August 1947, this happened. There is, of course, an important exception in the Places of Worship Act anticipating the Babri Masjid dispute. When this happened, government came up with a white paper. And one of the things the government of that day said in its white paper was, we will have to rebuild the mosque. It was a promise held out in the white paper. Of course, that promise was never fulfilled. We all know that's part of history now. They did two things. One, they passed a special law for acquisition of the place at Ayodhya. This was an acquisition of an area of almost 67 acres in and around the Babri Masjid, where the Babri Masjid stood. Along with that, they made a presidential reference. The reference was a one-point reference on a fact. Was a temple, standing at the place where now the Babri Masjid stands? So it went before a bench of 5 judges. There was a split verdict. The majority comprised Justice Venkatacharya, Justice Verma, and Justice G. N. Ray. The dissent comprised Justice Bharucha and Justice Ahmadi. And the way the two uh, opinions approached the case was quite different. As far as the majority was concerned, that provision in this law that the suits will abate because the property now vests in the central government, that provision, they say, is violative of the right to judicial review, which is again part of the basic feature of the Constitution. And therefore, they strike down that provision which abates the proceedings in courts. And they uphold the proceedings vesting the property in the central government on the understanding that the central government is like a statutory receiver. And once the case is decided and the question of title is decided, the government will hand over the property to the person in whose favor the title question is decided. Justice Bharucha and Ahmadi see it very differently. They see acquisition by the government of a place of worship is an anathema to secularism, which is part of the basic feature of the Constitution, and it simply cannot be permitted. So this is what Justice Bharucha says, and I want to read that because it's of great significance. Before we pass final orders, some observation of a general nature appear to be in order. Hinduism is a tolerant faith. It is that tolerance that has enabled Islam, Christianity, Zoroastrianism, Judaism, Buddhism, Jainism, and Sikhism to find shelter and support upon this land. We have no doubt that the moderate Hindu has little taste for tearing down of the place of worship of another to replace it with a temple. It is our fervent hope that the moderate opinion shall find general expression and that communal brotherhood shall bring to the dispute at Ayodhya an amicable solution long before the courts resolve it. And surprisingly, Justice Verma, in his majority opinion, says pretty much the same thing. And I'm going to read this part of it. Justice Verma is quite appreciative of the fact that lawyers of different communal faiths were appearing before the court, not going at each other's throats, and says, what a lovely harmonious hearing we had, and why can't we behave like this outside of the courts? The hearing left us, and I'm quoting Justice Verma, the hearing left us wondering why the dispute cannot be resolved in the same manner and in the same spirit in which the matter was argued, particularly when some of the participants are common and are in a position to negotiate and resolve the dispute. We do hope this hearing has been the commencement of that process which will ensure an amicable resolution of the dispute, and it will not end with the hearing of this matter. This is a matter suited essentially to resolution by negotiations, which does not end in a winner and a loser, while adjudication leads to that end. It is in the national interest that there is no loser at the end of the process adopted for resolution of the dispute, so that the final outcome does not leave behind any rancor in anyone. This can be achieved by a negotiated solution on the basis of which a decree can be obtained in terms of such solution in these suits. And this is how he ends it. Unless a solution is found which leaves everyone happy, there cannot be the beginning for continued harmony between we, the people of India. So the judges were deeply conscious that this is going to be a highly contested matter. And by this time, they had some idea of the nature of the evidence and the position of the parties. And they had the foresight, both the majority and the dissent, to say a negotiated settlement is the best way out. Unfortunately, that's not what happened. So I'll just go to the next phase of my. I must refer to one very important order on the same day that this judgment was pronounced. We are now on 24th October 1994. This is the day that Justice Venkatacharya retired. This judgment was pronounced on that day. Along with this judgment, Justice Venkatachalaya pronounced another judgment, holding Chief Minister Kalyan Singh, a sitting Chief Minister of Uttar Pradesh at that point in time when the incident happened, guilty of contempt of court. I presumed, and after all these years, that this was the same contempt proceedings for which Kalyan Singh was being proceeded against as a result of breaching the undertaking which resulted in the demolition of the Babri Masjid. But that's not quite true. That contempt was a suo motu contempt which never got taken up. So Justice Venkatachalaya, in the judgment which he delivers, very clearly says, we are disposing of the contempt notice issued to the UP government for the undertaking given prior to their 28th November 2012 order, where they had recorded those assurances. They were looking at the construction at the disputed site of a large platform using large volumes of concrete and cement, and right under the nose of the court, which was in teeth of all the assurances given to the court that the status quo would not be altered. So he says there is another suo motu contempt which I have issued to Kalyan Singh, but we are not dealing with it now. That contempt notice was issued on 18th December. That is about a week after the actual bringing down, more than a week, 10 days after the actual bringing down of the Babri Masjid. As it turns out, that suo motu contempt petition came up before the Supreme Court in 2022, by which time Mr. Kalyan Singh was not around, Mohammad Aslam Bhuria was not around, nobody was around, only Justice Kaul said, what's the point of flogging a dead horse? This is the exact word he uses. So it's a very poignant thing that a contempt, egregious contempt of court would not be taken up by the court, would not be listed by the court for as long as 2022, which is talking of 30 years. And there is no explanation for this. It's all quietly hidden away in some article or news item on the net. I myself was surprised. I had all along thought that punishing Kalyan Singh, which ultimately that was what the punishment he received. We had a very eloquent judgment by Justice Venkatachalaya expressing his complete anguish at what had happened. He talks of it as a dastardly act. He says how this command responsibility principle has to be applied. Somebody has to take responsibility, although it may be action of the government. The person who's highest in the government should actually pay for it. He says all of that, and you just should read this. This is the order passed on the date of his retirement. These petitions raise important issues as to amenability of the state and its ministers to be proceeded against in contempt for failure of obedience to the judicial pronouncements. These proceedings have the echo of the disastrous event that ended in the demolition on 6 December 1992 of the disputed structure of Ram Janmabhoomi Babri Masjid in Ayodhya. Thousands of innocent lives of citizens were lost, extensive damage to property caused, and more than all, a damage to the image of this great land as one fostering great traditions of tolerance, faith, brotherhood among the various communities inhabiting the land was impaired in the international scene. This is the line. Though the proceedings for suo motu contempt against the then Chief Minister of the state of Uttar Pradesh and its officers in relation to the happening of 6 December 1992 were initiated, those are pending and shall be dealt with independently. This was the date of his retirement, and that got lost in the Supreme Court records, never emerged till Justice U.U. Lalit became the Chief Justice of India and gave those instructions saying, let all old matters be listed before the court. And accidentally it came up before Justice Sanjay Kaul's bench, and they told him there's nothing left in the matter, it's all infructuous. So it ended in a whimper. And this is what Justice Venkatachalaya says. It is unhappy that a leader of a political party and chief minister has to be convicted of an offense of contempt of court. But it has to be done to uphold the majesty of law. We convict him for the offense of contempt of court. Since the contempt raises larger issues which affect the very foundation of the secular fabric of a nation, we also sentence him to a token imprisonment of 1 day. So this was the reaction of a Supreme Court of India to something which all of them, whether it's the majority judgment in the Ismail Faruqi case or the minority judgment, both of them recognize that it is a criminal act and it has shamed the whole nation. And yet, when it actually came to punishing the chief minister, sitting chief minister of contempt, it was a token imprisonment of 1 day. And I remember as a young lawyer seeing Kalyan Singh come in a grand procession and go away in a celebratory manner. And it was a thumping of the nose, you know. It was literally getting away with it completely. And listen what has happened. I mean, we know history speaks to us. So this is something that the court certainly has to be held accountable because it changes the course of political history. In between, and this is another feature of this entire case, and I wouldn't like to see it separate from the Babri Masjid case, are the triumvirate of the judgments on corrupt election practices by seeking votes in the name of religion. So you have on 11th December 1995, the infamous Hindutva judgment being pronounced by Justice Verma, where he says the words Hinduism or Hindutva are not necessarily to be understood and construed narrowly, confined only to the strict Hindu religious practices unrelated to culture and ethos of the people of India, depicting the way of life of the Indian people. In a series of cases, they try to explain that there is no inherent contradiction between the nature of secularism that was explained in Bombay to these Hindutva judgments where they're saying that secularism is even part of the religious scriptures like Rig Veda, Yajur Veda, Atharva Veda. So this again created a lot of controversy. It took another 22 years in Abhiram Singh for the court to say, when somebody seeks votes in the name of his religion, the word his doesn't necessarily mean the candidate, but it could be the voter or the opposing candidate. So this narrow construction of the word his in section 153.3 of the Representation of the People Act in the Hindutva judgment made people get away with inflammatory speeches because they got away under this narrow window saying when it says his, it means only the religion of the candidate and not the religion of the voter or the religion of the opposing candidate. So these corrective courses happened too little, too late, and in between, you know, the political history of the country has changed. But the Babri Masjid tale doesn't end here. If you think it does, you're mistaken. 2 FIRs were lodged after the Babri Masjid was brought down. One against lakhs of people who were supposed to have been involved in the actual bringing down, and another against the top leadership of the BJP of that time, including Sri L.K. Advani, Sri Murli Manohar Joshi, Ms. Uma Bharti, and so on, even Sri Bal Thackeray, for part of the larger conspiracy to bring it down. I'll cut through the details. It has a tortuous course. In 2017, it accidentally lands up before a bench of Justice Nariman. And he looks at it and he's shocked. He says, 1992, we are in 2017, the trial hasn't moved an inch. So he says, I'm going to revive the conspiracy charges. I'm going to set a timetable for completion of the trial. In fact, he's spoken at an event very recently when I heard him say this. So I don't want to repeat what he has said. But it's because of his judgment that the trial at all happened. But at the end of the day, on 30th September 2020, 32 of the 49 were acquitted. The remaining 17 had died. The judge said, there is no evidence to show there's any conspiracy. So what do you do? So 2 residents in Ayodhya went to the Allahabad High Court in an appeal against this because their houses in Ayodhya had been demolished during the riots that broke out. The High Court told them, no, you have no locus. We can't say that you were victims of this bringing down of the Babri Masjid. So that appeal was dismissed, and that happened on 9th November 2022. So the aftermath of the Babri Masjid demolition has also been a disappointment as far as its journey through the courts is concerned. What we have today, of course, to discuss is the Babri Masjid decision itself. And there are very interesting facets to it. It was going to take me 10 minutes, and you should bear with me. Initially, the case just kept pending. In 2010, the Allahabad High Court had decided. In 2012, they granted a status quo order in the Supreme Court while admitting the appeals. At one point in time, there was an attempt to get the case referred to a larger bench of 5 judges, saying that there are observations in the Ismail Faruqi case, where, of course, the acquisition law was upheld in a majority of 3-2, and observations in Bombay, which will require this case to go before a bench of 5 judges. But 3 judges of Supreme Court on 14th March 2018, declined to do that. On 27 September 2018, they again declined to refer it to a larger bench. But something dramatically changed when Justice Deepak Mishra became the Chief Justice. On the administrative side, he issued an order on 8 January 2019. I think this was some 2 months before his retirement, constituting a 5-judge bench to hear the Babri Masjid dispute. The case goes under the cause title. The lead case is M. Siddiq versus Mahant Suresh Das. The court waded through a whole lot of evidence, but what is significant from what I'm going to say now is the attempt at mediation. So on 8th March 2019, a panel of mediators comprising Justice Khalifullah, a former judge of the Supreme Court, Sri Ravi Shankar, and Mr. Sriram Panchu, a senior advocate, was constituted. Time was granted to the mediators to complete the mediation proceedings, and that time was extended 1st to 10th May 2019. Since no settlement had been reached, on 2nd August 2019, the hearing of the appeals was directed to commence from 6th August. During the course of hearing, a report was submitted by the panel of mediators that some of the parties desired to settle the dispute. The Supreme Court, by its order dated 18 September 2019, observed that while the hearings will proceed, if any parties desired to settle the dispute, it is open for them to move the mediators and place a settlement if arrived at before the court. Final arguments were concluded on 16th October 2019. This date is very important. On that very day, the mediation panel submitted a report titled Final Report of the Committee, stating that a settlement had been arrived at by some of the parties to the present dispute. The settlement was signed by Mr. Zufar Ahmed Farooqi, chairman of the Sunni Central Waqf Board. Though under the settlement, the Sunni Central Waqf Board agreed to relinquish all its rights, interests, and claims for the disputed land, this was subject to fulfillment of certain conditions stipulated. The settlement received by the Supreme Court from the panel was viewed by it as not having been agreed to or signed by all the parties. Now, we all know we go before the courts. In so many matters, the court says, why don't you try a settlement? We come back and tell the court, sir, we are almost 70% through or 80% through. You know, if you judges sit with us, with the parties, maybe you can push us through the settlement. That's normally what is done. But here, there seems to be a conscious decision not to push this mediation process forward, although the mediators are telling the Supreme Court that an agreement has been arrived at, but not signed by all the parties. So if that sat with the parties, maybe, I'm just saying maybe, some negotiated settlement which, you know, judges of in the Ismail Farooqi case had asked to be considered, that option could have been considered. Instead of arriving at a judgment, and if I read before you, the findings in this judgment, it's quite astounding. One, they foreground the entire discussion by a discussion of the Places of Worship Act. And this is what is said. There is a purpose underlying the enactment of the Places of Worship Act. This is in the main Ayodhya judgment. The law speaks to our history and to the future of the nation. Cognizant as we are of our history and of the need for the nation to confront it, independence was a watershed moment to heal wounds of the past. Historical wrongs cannot be remedied by the people taking law into their own hands. In preserving the character of the places of public worship, Parliament has mandated in no uncertain terms that history and its wrongs shall not be used as instruments to oppress the present and the future. The evidence is discussed in great detail. This is what the judgment says: the adjudication of civil claims over private property must remain within the domain of the secular if the commitment to constitutional values is to be upheld. It goes on to say that the ASI report has left unanswered a critical part of the remit which was made to it, namely the determination of whether a Hindu temple had been demolished to pave way for the construction of the mosque. ASI's inability to render a specific finding on this facet is certainly a significant evidentiary circumstance which must be borne in mind when the cumulative impact of the entire evidence is considered in the final analysis. Then they talk about history, because large number of historical texts are cited before them. They say there are dangers in interpreting history without the aid of historiography. Application of legal principles to make deductions and inferences out of historical context is a perilous exercise. One must exercise caution before embarking on the inclination of a legally trained mind to draw negative inferences from the silences of history. Silences are sometimes best left to where they belong, the universe of silence. So, what they say in the judgment, throughout the judgment, and how they conclude, doesn't seem to be a logical outcome at all. And this is again the Supreme Court telling us, because gazetteers, travelogues, all of that are referred to. The law recognizes that where since time immemorial, and this is in para 1140 of the judgment, this is where the shift happens, where they're trying to take a pragmatic approach. The law recognizes that where since time immemorial, worship has been offered at a land with a mosque, the land is presumed to have been dedicated for religious purpose, and even absent a dedication is waqf for user. However, and this is the crucial line, this may not be extended to the extinguishment of competing and established religious rights of another community in the same property, particularly in the face of the evidence noted above. It doesn't flow from the evidence noted above, because they're not able to find evidence to show there has been worship by the Hindus in the place where the mosque stands. And these are specific findings. Para 1219, on a preponderance of probabilities, there is no evidence to establish that the Muslims abandoned the mosque or ceased to perform namaz in spite of contestation over their possession on the inner courtyard after 1858. Oral evidence indicates the continuation of namaz. This is even more significant. On 6/12/1992, you should remember this is an authorless judgment, so-called authorless judgment, but the author himself said that he wrote it after talking to the deity, so there's no problem on that. On 6th December 1992, the structure of the mosque was brought down and the mosque was destroyed. The destruction of the mosque took place in breach of the order of status quo and an assurance given to this court. The destruction of the mosque and the obliteration of the Islamic structure was an egregious violation of the rule of law. This is unanimous Supreme Court telling us on 9th November 2019 in para 1222, their conclusions on analyzing the entire evidence. This is true, that this is a clear finding. The Hindus have been in exclusive and unimpeded possession of the outer courtyard where they have continued worship. The inner courtyard has been a contested site with conflicting claims of the Hindus and Muslims. And look at this finding. On the balance of probabilities, there is clear evidence to indicate that by the worship, the Hindus in the outer courtyard continued unimpeded in spite of setting up the grill brick. Their possession of the outer courtyard stands established together with the incidents attaching to their control over it. Now they come to the inner courtyard. As regards the inner courtyard, where the Babri Masjid stood, there is evidence on the preponderance of probabilities to establish worship by the Hindus prior to the annexation of Oudh by the British in 1857. Then they go on to say, the report of the Waqf inspector of December 1949 indicates that Muslims were being obstructed in free and unimpeded access to the mosque for the purposes of offering namaz. However, there is evidence to show that namaz was offered in the structure of the mosque, and the last Friday namaz was offered on 16 December 1949. The exclusion of Muslims from worship and possession took place on the intervening night between 22nd and 23rd December, when the mosque was desecrated by the installation of Hindu idols. The ouster of Muslims on that occasion was not through any lawful authority, but through an act which was calculated to deprive them of their place of worship. During the pendency of the suits, the entire structure of the mosque was brought down in a calculated act of destroying a place of public worship. The Muslims have been wrongly deprived of a mosque which had been constructed well over 450 years ago. So, one reads this judgment and reads these findings. It beats one as to the conclusion that is reached as an end of the whole exercise. Because they say now that they're exercising the powers under Article 142 to bring complete justice. And what is complete justice? The central government shall, within a period of 3 months from the date of the judgment, formulate a scheme pursuant to the powers vested it under Section 6 and 7 of the Acquisition of Certain Area at Ayodhya Act. The scheme shall envisage the setting up of a trust with a board of trustees or any other appropriate body under Section 6. The scheme to be framed by the central government shall make necessary provisions in regard to the functioning of the trust or body, and this is the important line, including on matters relating to the management of the trust, the powers of the trustees, including the construction of a temple and all necessary incidental and supplemental matters. So what is so significant is that you're using your Article 142 power to give a direction that nobody asked for. If you go the prayers in the suits, there's not a single prayer saying, please direct them to construct a temple. Why did the Supreme Court have to direct the framing of a scene for construction of a temple? Beats anyone reading this judgment. There's no legal basis for it. There was no prayer. Therefore, there's no opposition to that prayer. There's no issue framed. In a normal civil suit, this are the basic questions one would ask, right? Where did this come from? Who asked for it? There is no indication that any central government lawyer was there asking for this relief, or any of the Hindu groups asked for it. We know there are arguments in court. The arguments was to say that Ram Lalla is a divine being and he has the locus to file a suit, which they recognized. They also said that Janmasthan is an entity by itself, which they did not agree. So there are many issues which they've answered, some in favor, some not. But there was no issue on constructing a temple in the place where the mosque stood. So this, I would submit that, this is completely outside the realm of the suits themselves, which were there before the court. There is no noting of any argument by anyone saying, please direct them to have a temple where the mosque stood. So this is something that has beaten a reader like me. I don't know, I could be wrong. In the question and answer, we can have someone who have a different point of view. So the main points I want to make on this whole Ayodhya episode is this. There is still an aftermath. The Ayodhya episode is not ended. Despite the Supreme Court, 5 judges talking about the Places of Worship Act, we've had suits emerge everywhere. Suits regarding Yanvapi, suits regarding the Eidgah at Mathura, Sambal, and there are now 17 suits all over the country. So it's very commendable that Justice Sanjeev Khanna as a CJI put a temporary halt, saying none of these suits will proceed till we decide on the validity of the Places of Worship Act. But those are all waiting in the wings. So the sooner the court decides on the validity of the Places of Worship Act, the better. Because otherwise, there are going to be more and more suits all over the country. Some of the main points I want to make is this. One is about the role of judiciary at every stage. Not many would know, there are only 2 suits that were finally decreed by the Supreme Court. Suits 4 and 5. Suit number 4 was by the Sunni Central Waqf Board. Suit number 5 was by Bhagwan Shri Ram. That suit by Bhagwan Shri Ram was filed by a retired judge of the Allahabad High Court. His name was Devaki Nandan Agarwala. He went as the next friend of the deity. So when we talk of the role of the judiciary, one is to what they do on the judicial side. But what they do on the personal side is also very important. Somewhere it reflects who they are and what their inclinations are. It is definitely a matter of personal choice. Nobody's questioning that at all. But when you hold a public office and discharge a public function, how you hold yourself out is very important. We talked about constitutional morality. The constitutional morality that Ambedkar had in mind is imbibing of constitutional values by people in administration. He knew that if that did not happen, if somebody in administration didn't believe in equality, didn't believe in non-discrimination, didn't believe in secularism, then the whole constitutional framework would break down for the common person. He would say, okay, it's all fine, all these great words in the constitution, but it doesn't work in my case. Because this section officer or this peon is not doing what he's supposed to do. And Ambedkar had great foresight in anticipating this. That's what he talked about, constitutional morality in that sense. Say certain judges stayed the course. The same judges who heard the Ismail Farooqi case were also part of the Hindutva judgments. So I wouldn't consider it a mere coincidence. Of course, Justice Verma is supposed to have regretted having written the Hindutva judgment and been, rued the possibility of it being misquoted and misunderstood. But people understand the way they want to understand. Apparently, the 1996 manifesto of the BJP, they quoted Justice Verma's judgment to say, finally, we have a wonderful explanation of what Hindutva is all about. So these small things that we miss about the role that judiciary plays in shaping, the political discourse is something we have not paid attention to. And the Babri Masjid case is an excellent case study for how one case with its multifarious branches of litigation can actually shape the course of political and legal history in the country. No action on the contempt. So this is a classic case of impunity. A chief minister not punished at all. Why? Because the court forgot that it issued suo motu notice of contempt to him. Just forgot. It's an amnesia, an institutional amnesia. And unforgivable according to me, because such an egregious criminal act, even in 2019, 5 judges of the Supreme Court are telling us it is an egregious act, violate of the rule of law, and the persons who have perpetrated it have gone. You have a trial which is taking place after some 2 decades, ending 3 decades, ending in acquittal. And what does the judge say? There is no evidence. I mean, there are enough videos, enough, writings, contemporaneous witnesses who have watched all these things. And we are asked to believe that absolutely no evidence to say there's any conspiracy in bringing down the Babri Masjid. So the question of impunity also arises. And there is a whole addenda to this judgment, the title to which actually says whether the disputed structure is the holy birthplace of Lord Ram as per the faith, belief, and trust of the Hindus. This was an issue only in one of the suits, not in all the suits. And there's a whole discussion in the addenda, which is again authorless. It says it's by one of the judges who wishes not to be named. And it comes to a different conclusion altogether. It says there's conclusive proof on the faith and belief, on the basis of faith and belief, that there was a temple dedicated to Lord Ram before the Babri Masjid was built there. And this completely stands at odds with the majority judgment. And yet we're asked to read the addenda along with the main judgment as if it's simply a concurring opinion. It is not. If somebody keeps the majority opinion, the main opinion and the addenda, they will know that they don't square up at all. I also have a problem with not exploring the mediation option. What was the tiring hurry? Why could they have not waited a bit longer? The only explanation is November 9, 2019 is about 10 days before the retirement of Justice Gogoi. So I'm just saying many of these orders, I didn't dwell too much on it, they're either pronounced on the day of retirement or 1 day or 1 week before retirement. So something else is driving. I mean, this is an issue too big to be hurried through. You know, on printed SEC pages, it is a whole volume. In actual printed pages, it runs to thousands of pages. And we're asked to believe that the hearing ended on September 18th, 2019, and a judgment was ready on 9th November 2019. Did all the other judges get to read the draft? I really ask, I've been a judge myself. If I'm given a 2,000-page, 3,000-page judgment, I would need time to go through it. So I don't know how to respond or react, but I am disappointed that the mediation option was not explored. Particularly, they should have recalled what 5 judges earlier said when they were dealing with the presidential reference. Both those opinions said the best way forward is a negotiated settlement. And there was a possibility of that from their own writing in this judgment, that the court was told an agreement had been reached, only that some people had not signed. And they should have explored that possibility. And last is the hydra-headedness of this whole thing. You know, the same judges who are part of this bench, and I'm not finding fault with their having celebrated, having a photo together, having gone to a 5-star hotel and celebrated. It's all okay. I mean, it's all news for the media, not for me. What I'm concerned is the sticking to your judgment on Places of Worship Act. There are at least 5 pages devoted to the Places of Worship Act. And what do you do in August 2022? You say if somebody wants to have a video made, a survey made in a non-invasive way, we'll allow that. So what has happened is you're not stuck to your own order in the main judgment in Ayodhya, in the Babri Masjid case, and you've allowed it to get diluted. And that has serious repercussions. Today there are 17 suits all over the country saying that if you've allowed it in one, so somebody says there's a shivling, another group says no, it is a fountain, it's always been a fountain. Now that becomes a matter of dispute. You could have avoided all this by saying we will not entertain any fresh suits, period. This is what the act says. And all those suits can wait till we decide on the validity of the act. By all means, revive the suits if we find the act to be unconstitutional. But you must stay these suits. Because what is the message going down the line to the district judiciary? That yes, you can entertain these suits. Some will get entertained, some will go 2 steps forward, because in one of those places, one group is allowed to enter from the north, the others are allowed to enter from the south. You've already altered the status quo then. And there's no meaning then to the Places of Worship Act. Now, there are other cases which depict large unease within the court. One is the Sabarimala case. I'll just spend 2 minutes on it. Within 2 months of the judgment being delivered, whereby a 4:1 majority, they strike down a prohibition on the entry of women between the ages of 10 and 55 into the shrine. Another review bench, comprising 4 of the ones who originally were there, is constituted. And now one judge who went with the majority is now with a new majority which says we'll review the judgment. So the review judgment is allowed by 3:2. When that is put in question, that, because one judge retired and went, which in this case was Justice Deepak Mishra, substituted by Justice Gogoi, can you just now allow a review petition? That is referred to 7 judges. And the entire judgment is put in cold storage, saying there are other issues concerning essential religious practices arising out of the Dawoodi Bohra, genital mutilation case, the Haji Ali entry case, and some other cases, saying it all involves a larger question, so we'll put it in cold storage. And this shows the dichotomy between individual judges on how they should approach this issue. And this doesn't augur well that such a short time you're able to reverse. Earlier constitution bench judgments, we would think it settles the law for at least some time. Here it is not surviving even for a month or 2. And this doesn't augur well for a Supreme Court of India where people are looking at finality. The last, I would say, the hijab case. Again, 2 diametrically opposite approaches by the 2 dissenting judges. What was the case about? 2 young second-year pre-university students, female students, in a village, in a town near Udupi in Mangalore, entering the school premises, the college premises. They stopped at the gate. The guard tells them, you can't enter because you're wearing a hijab. They say, but there's no rule against wearing the hijab. We've always worn it. We've always been going to school with the hijab. He says, no, you cannot. 2 days later, the government of Karnataka passes a notification saying in all government-aided schools, government schools, the dress code will be prescribed at the school and you have to abide by the dress code. The dress code obviously is targeting against a particular religious community. That is challenged. The Karnataka High Court upholds that notification. It is taken to the Supreme Court, and the 2 judges have a very different approach. So one judge says that we have to ask ourselves, is wearing a hijab an essential religious practice? Which is actually the approach in many of these judgments, which is problematic, because this then takes the judges into the realm of theology. You will find many judges getting into the whole discussion of what is Hinduism, what are essential religious practice of the Hindus, again, of Islam, of Dawoodi Bohras, of any religion. They'll start asking these questions, although judges are not equipped. They can only vicariously, step in and read texts and be impressed by one or not impressed by the other. But it's actually a dangerous exercise because judges can get it wrong. And this is what the other judge points out. So one judge says, and this is what I'm reading, students are at liberty to carry their religious symbols up to the school, but in a pre-university college, they should look alike. Look at this. Students should look alike, feel alike, think alike, and study in a cohesive, coordinated sense. So the whole understanding of what uniform is so different. And this judge says secularism is available to all citizens, but if you allow some people of certain religion to wear religious symbols, that will be antithetical to secularism. The judges told, listen, for Sikhs, they're able to wear their turbans, they're carrying their kirpans. He says, no, in the constitution there is a provision for that, which is true. But that is not decisive of the issue. So the other judge asks a very simple question, and he goes from a very different angle. He says it is necessary to have discipline in schools, but discipline not at the cost of freedom, not at the cost of dignity. Asking a pre-university schoolgirl to take off her hijab at her school gate is an invasion of her privacy and dignity. It is clearly violative of the fundamental right given to her under 19(1)(a) and 21 of the Constitution. The right to her dignity and her privacy she carries in her person, even inside her school gate or when she is in her classroom. It is her fundamental right, not a derivative right. And he says something very nice. He says, it's a wonderful sight to see young schoolgirls with their bags on their back walking into a school. Our schools, in particular our pre-university colleges, are the perfect institutions where our children, who are now at an impressionable age and are just waking up to the rich diversity of this nation, need to be counseled and guided so that they imbibe our constitutional values of tolerance and accommodation towards those who may speak a different language, eat different food, or even wear different clothes or apparels. This is the time to foster in them sensitivity, empathy, and understanding towards different religions, languages, and cultures. This is the time when they should learn not to be alarmed by our diversity, but to rejoice and celebrate this diversity. This is the time when they must realize that in diversity is our strength. I don't need to tell you who this judge is, you will all understand. So, this is where we are as a country, that we are at a very critical juncture where the future generation of ours must be sensitized to constitutional values. If they're going to read texts that are distorted, if they're going to have their neighbors, their classmates accuse them of being Pakistani because they happen to be a Muslim, and this is happening in Delhi schools, it scars them. It scars them very deeply. And they grew up with a lot of fear and insecurity, which is not fair at all. This is not the country we were born into. This is not the country we grew into. And this is not our strength. Our strength is in our diversity, our plurality. And I'm afraid, and I come to the last part, that we need to look inwards as a judiciary. I don't want to steer too much of the main theme of the topic. We don't ask, who are our judges? What are their religious beliefs? What are their practices? We all say it's all private affair of a judge, no difficulty there. If the judge keeps it private, there's no problem. If after getting sworn in as the Chief Justice of India, the next day I'm found in Tirupati, and it's a public spectacle. See, there's no harm in visiting a place of worship. Absolutely nothing. I mean, nobody's suggesting that the judge should not go to a place of worship. But if you make a public spectacle, and this is entirely, we've all been judges. I mean, I can tell you some in the crowd, we are very careful on what we will allow to get publicized. We don't invite the press, we don't invite the cameras into occasions like this. Because the message that goes out to the public is very important. Whom am I holding out to be? And people will put two and two together. This is the whole thing about justice being seen to be done. I should not be mistaken as suggesting that judges shouldn't go to temples. Of course not. But it is something private, it's personal. Keep it that way. The minute you make a public spectacle, you're in difficulty. In Delhi High Court, and I know I have a former colleague here, there was an occasion for inauguration of a foundation stone laying of the medical center. A priest was called. A Havan was performed. The Gayatri Mantra was recited. There are judges of different religious calling. One of them protested. He said, why are we having this in a public place? This institution is a secular institution. And he had a valid point. We have to be sensitive. We can't ignore these, this is not merely symbolic. It's beyond symbolism. I'm finding there's a stridency, a certain stridency in these functions that we organize in these public institutions. I'm reminded of an incident of the Hirakud Dam opening, and this I know firsthand from one of the relatives who was an IAS officer at that time. So Panditji was to be brought by a helicopter. Somewhere they had constructed helipad. And there were two of them. There was a chief engineer called Tirumalachar, who was a Vaishnavite from Tamil Nadu, very devout person, very excellent as a civil engineer, very highly respected. So this was a Sunday, so he had calculated the auspicious time for inauguration of the Hirakud Dam. And it was between 4:30 and 6 was not the good time, so it had to be either before 4:30 or after 6. So there was another person whom he didn't get along with, almost in the same rank. He was asked to go and receive the Prime Minister. And while the Prime Minister was driving down, he asked the Prime Minister, he must be wondering, how come, your speech is first and the inauguration is later? Yeah, Panditji said, yes, I'm wondering why. He said, no, this other engineer, he has this thing about Rahu Kal. So Panditji being Panditji says, okay. The minute they got off the car, he went straight and cut the ribbon. And the other person was very upset. But this is the point about what do you do in a public display of an occasion like this. I don't know, maybe today we are on the other end of the spectrum. You know, we have heads of state, you have people holding the highest positions, inaugurating temples, laying foundation stone for temples. Look at Mamata Banerjee. She uses the funds, state funds, to have a temple for Lord Jagannath in West Bengal. I'm just saying that we've crossed all those so-called barriers. We have Chandi Path being recited in an election campaign. One person inaugurates his campaign from the Hanuman temple in Delhi because he has to keep, you know, at par with the other dominant political force that he's contesting against. So we've lost our, lost our moorings somewhere. We're abandoning the constitutional values. We are letting someone set the tone. And that we should guard against. We may be a numerical minority, but let us stick to our belief in these constitutional values. Let us not surrender these constitutional values. And it's important not just for us, but our future generation. They should feel secure to live here. They should not be afraid to go by the Constitution. And this spirit should come through the writings of our judges, in the behavior of and conduct of our judges. I'm really concerned about what we also do as an institution, and I hope the message has gone across. I'll just end with one humorous episode. The dear friend of mine, who's a former judge of the Madras High Court, now he'd given a judgment in a very highly contested matter between two sects of Vaishnavites. I don't know how many South Indians are here. So one of them wears a tilak in a U shape, the other is with a Y shape. And just to add some spice to this, there is a temple, a Vaishnavite temple in Kanchipuram in the south. And there is a temple elephant. The dispute whether that elephant should display the Y mark or the U mark went thrice to the Privy Council. So that's how highly contested. So this judge had decided it, and the next day was the headlines saying, judge says so-and-so holds so-and-so. So as he was entering the court the next morning, the fellow judge also entered the lift along with him and turns to him and says, Chandru, wonderful judgment, great judgment. So Chandru says, thank you. He says, but Chandru, you did not write it. He tells you and you write. So Chandru being Chandru says immediately, Tripathi, very good at Tripathi, he says, I have one doubt. He says, what doubt? He says, when this judgment gets reversed, who will write that one? Thank you.